Will the clerk please call calendar 312?
House Calendar 312, favorable report of the Joint Standing Committee on Government Administration and Elections, an act revising the regulation review process.
Representative Becker.
Good afternoon, Mr. Speaker.
Good afternoon, sir.
Mr. Speaker, I move for acceptance of the Joint Committee's favorable report and passage of the bill.
The question is acceptance of the Joint Committee's favorable report and passage of the bill. Representative Becker, you have the floor, sir.
Thank you, Mr. Speaker. Mr. Speaker, the bill before us now is designed to change the regulation review process a bit. There's a little-known statute that's on our books right now, 4-189I, that sets up the process for review today. And that process tasks the Regulation Review Committee with handling the entire process, setting up a schedule of reviewing each state agency's report on their regulations, and a schedule set over a 5-year period. Turns out there are 79 state agencies, Mr. Speaker. 79. That would work out to 16 per year for this one committee to have to address. In the report that the agencies are to submit, they're supposed to identify regulations which are obsolete, which may conflict with existing law, which haven't been used over the last 5 years, or about which they have received a written complaint. That could be from a business, an individual, a municipality, what have you. And upon receiving that report, Mr. Speaker, the committee is then supposed to set up a public hearing jointly with the Committee of Cognizance that oversees that particular agency. Mr. Speaker, the Regulation Review Committee is not made up of the subject matter experts that oversee that agency. If, to the extent that we have those experts, they reside on the Committee of Cognizance. And so it kind of calls into question of what questions would Regulation Review Committee members ask at that public hearing? Why do we need to be there? In addition, upon conclusion of that public hearing, either the agency could submit a regulation to change what needs to be changed, or if legislation is needed to authorize the agency to do so, or the legislature wishes to compel an agency to do so, it's the Committee of Cognizance which must bring that legislation to the floor, because as we know, the Regulation Review Committee is the only committee in the General Assembly that cannot bring a bill out on the floor. So it begs the question, why do we complicate the process by having the Regulation Review Committee in that? And this is reminiscent of something we did in 2012 when we had PRI overburdened with reviewing 75 different programs over a 5-year basis, and we passed a law back then delegating that responsibility out to the Committees of Cognizance and making it more workable so it would actually happen. In this instance, the reason why we have so many agencies is the definition of agency under state law is essentially anyone with rule-making authority at the state level. So it's not just our state departments, but also boards and commissions. And so as such, this is an overwhelming task for Reg Review. It hasn't been done, by the account of folks who've been here much longer than me, since the mid-90s. It was done once and not since then. And I suspect that that's in part because of the overwhelming task that is there. So this bill that's before us would, again, delegate that responsibility to the Committees of Cognizance. The greatest weight or the greatest burden would fall upon our GAE committee. 15 of those agencies would fall under its cognizance. And so rather than asking GAE to do that over 5 years, or any committee to do it over a 5-year period, we would extend that period to 7, so that the GAE committee, the one hit the hardest, would only have to do 2 per year with the exception of 1 year. So that's the bulk of, or the main point to this bill, Mr. Speaker. There are also technical changes in there that try to make the process a lot smoother. Those suggestions came from the governor's office. They've been vetted with LCO and believe that they will make the process more efficient. That's the bill. And then, Mr. Speaker, there is an amendment on file, and I would ask the clerk to call LCO number 4477 that I be granted permission to summarize.
Will the clerk please call LCO 4477, which will be designated House Amendment Schedule A.
House Amendment Schedule A, LCO 4477, as introduced by Representative Becker, Gentilis, Smith, Senators Casano and Senator McLaughlin.
The representative seeks leave of the chamber to summarize the amendment. Is there objection to summarization? Is there objection? Hearing none. Representative Becker, you may proceed with summarization.
Thank you, Mr. Speaker. Mr. Speaker, this amendment has additional technical changes. The first being one that was actually asked for by the Connecticut Realtors that would allow for certain typographical errors and spelling, grammar, punctuation, those types of changes, technical changes that have no substantive effect to be made without having to go through the entire regulation review process. The specific example here is with respect to the property disclosure form. And Mr. Speaker, that form is actually comes into being through the regulation review process. And it was noted that there's a statutory provision that requires a question on underground storage tanks to be included. And something happened along the lines in the reg review process where the word tank was left out. So on the form, the word tank is missing. Currently, in order to make that change, they would have to go through the entire process, including a public hearing period, public notice period, public comment period. And this would allow that change to happen in a more efficient fashion where the change would just be submitted to the Regulation Review Committee for approval without
Do you move
public
adoption,
comment.
sir?
Sorry?
Do you move adoption, sir?
I move adoption. Thank you, Mr.
The
Speaker.
question before the chamber is adoption of House Amendment Schedule A. Will you remark on the amendment?
Yes, Mr. Speaker.
Representative Becker.
So, Mr. Speaker, there are also other technical changes that would enable or that would change the effective date of any emergency regulation from the time it's submitted to the Secretary of State to the time it actually is posted on e-regs, on the new e-regulation system, so the public will actually have notice of it. And there are other technical changes. I'll leave it at that, Mr. Speaker, and be happy to take any questions.
Will you remark further? Representative Smith of the 108th.
Thank you, Mr. Speaker. Good afternoon, sir.
Good afternoon, sir.
Mr. Speaker, first I want to commend Representative Becker. What a fabulous job he's done, not only on the committee, but especially with this bill. When Representative Becker gets his hands around something, we're always thrilled with the outcome. And he did a wonderful job here, taking an onerous task and really bringing a great amendment before the chamber today. So I commend him on his work and appreciate it as the ranking member. He has worked closely with both sides of the aisle to make sure that everybody was on board. And I can't thank him enough for that effort. I do have a few questions through you, Mr. Speaker, if I may.
You may proceed, sir.
Thank you. I guess the first question I had, and there was looking at the amendment, lines 2 through 4, there was, what is the rationale behind that change to put the new language in there through you, Mr. Speaker? Representative
Becker.
Through you, Mr. Speaker, thank you for the question, and thank you for the compliments, Mr. Ranking Member of GAE, Representative Smith. The purpose for the change, again, this stems from a request from the Connecticut Realtors. They had a property disclosure form, and this would apply to other things as well, but specifically what triggered this was a property disclosure form in which there's a statutory requirement that they include a question regarding underground storage tanks. And the form is created through the regulation review process, and somewhere along the lines during that process, the word tank was omitted. So their form currently does not have the word tank as statutorily required on it. They want to make that correction, and under current law, they would have to go through the entire regulation review process again, including a public comment period or a public hearing period, and this would enable them to make that request and have it go directly to the committee without that public comment period. And notice it's restricted to spelling, grammar, punctuation, formatting, typographical errors with no substantive changes. So this is something about which I don't think we would want there to be a public hearing. I don't think anyone would show up to testify. Through you, Mr. Speaker.
Representative Smith.
Thank you, Mr. Speaker, and thank the representative for his answer. So if there was a change such as this, such as you described, where the word form was left out and we needed to add that in, the process would be then for them to modify the form, bring that before the committee, and the committee then would vote on it. Is that the process as you understand it through you, Mr. Speaker?
I'm sorry, Mr. Speaker, I couldn't
Representative
hear
Becker.
I'm sorry, Mr. Speaker, I could not hear the question.
Representative Smith, restate your question, please.
Yes, so the question is, in a situation as described where it was a formatting or a word was left out, and in the past we'd have to go through a public hearing, go through the expensive process of a public hearing, and as I understand the good representative now, that the process would be just to bring the change to the committee level. And my question through you, Mr. Speaker, is what would happen then? Would the committee then have to take a vote on the change to make it official, or just have knowledge of the change as being proposed? Through you.
Representative Becker.
Thank you, Mr. Speaker. Through you. Thank you for the good question. The omission of a word and the correction of an omission would also be considered a typographical error under this amendment and would fall within the intent of this amendment. And in the regulation review process, the committee itself has the power to either approve a proposed reg or reject it with or without prejudice. It could disapprove or reject without prejudice. Absent any committee action, it could be deemed approved after a certain period of time. So in one of those ways, the committee would handle the matter. Through you, Mr. Speaker.
Representative Smith.
And thank you again, Mr. Speaker. And so that was one of the questions I had just to dig down a little bit deeper. So in situations like we're going into now, where hopefully we'll be out of session a week from today at midnight, and a change is then proposed to one of our committees here at the Capitol, and we're not in session. Now, obviously, we can be called back in for a committee meeting at any time, but it may be inconvenient for some members during the off session to get back up here. How does that work then if in the middle of the summer a proposed change is being offered up and the committee is called in but does not meet, as I understand it, over a certain period of time, and I'm not sure what period it would be before the regulation as proposed would then become official? So what period of time are we talking about? Through you, Mr. Speaker.
Representative Becker.
Through you, Mr. Speaker. The Regulation Review Committee is a year-round committee. We actually have regularly scheduled meetings each and every month of the calendar year. And on a newly proposed regulation, the time period during which the committee has to act or the regulation is deemed approved is 65 days. Through you, Mr. Speaker.
Representative Smith.
Thank you for that clarification. And I know under the old process, there was situations where if there was an emergency and a regulation had to be passed right away because of the emergency, there was a process in place for that. How does that, this amendment proposed today affect those emergency processes? Through you, Mr. Speaker.
Representative Becker.
Through you, Mr. Speaker, the actual process through the committee is unchanged by this amendment. What is changed, however, is the use of the e-regs system and the fact that the the emergency regulation would become effective upon it being uploaded to the e-reg system following approval by the Regulation Review Committee, as opposed to approved upon submission to the Secretary of State, because a submission to the Secretary of State without posting on e-regs would not make that regulation apparent to the public. Through you, Mr. Speaker.
Representative Smith.
And again, Mr. Speaker, thank you, and thank the representative for his answer and clarification on that. I know this this change will put some more work back at the committee level. For some committees, a little bit more work than others. For example, the Government Administration's Elections Committee will have much more work than some of the other committees. So when this was first proposed, you know, I'm thinking, how come we want this much more work? Do we really need it? We have enough work to do. Our ranking member, who is, as you know, leaving after this session, he didn't really have too much concern about it. He said, you'd be able to handle it. Don't worry, I won't be here, and good luck to you. No, he didn't say that, obviously, but but the reality is, I mean, some committees will have much more work than others, and I'm wondering if the good representative has reached out to some of the other committees besides GAE in which he sits and see how they felt about this proposal. Through you, Mr. Speaker.
Representative Becker.
Through you, Mr. Speaker, as the ranking member stated, GAE actually is bearing the brunt of this. They have 15 of the agencies. That's the most of any committee. And in order to try to reduce the amount of work, rather than keeping the time period at the current 5 years to schedule all of these reports coming in public hearings, we stretched the time period to 7. So even the most overworked committee in this process will only have to do 2 per year, with the exception of 1 year where they would have to do 3. And there's nothing that says the committee has to do it during session. They could do it off session if they choose, anytime the committee chooses to do it. So somewhere over the course of the year to hold 2 public hearings for the most overworked committee hopefully will prove to be something they can handle. Thank you, Mr. Speaker.
Representative Smith.
Mr. Speaker, again, thank the representative for his clarification on that. Ladies and gentlemen, this bill as initially proposed, and I'm sure with this amendment, has the support of the National Federation of Independent Businesses, the Connecticut Council of Small Towns, CBIA, Connecticut Water Works Association, and the reason being is it makes the process much more efficient. You know, anytime we can strive to be more efficient up here, it's a step in the right direction. I think we all know that government kind of works at its own pace, sometimes much too slow for some people, including myself. So this is a step, in my mind, in the right direction. I'm happy as a member of the GIE to be taking on this, look at some of these regulations, see, do we really need them? Are they efficient? Are they working? Do we need others in its place? So and it makes the most sense, at least to me, logically, to have the committee that deals with these issues on a week-in, week-out basis to actually address them, as opposed to have one committee trying to figure out, well, what's going on in judiciary or government administrations or housing or whatever it may be. So I urge my colleagues to support this amendment, as I do as well. Thank you, Mr. Speaker.
Thank you, sir. Representative Zupkis of the 89th.
Thank you, Mr. Speaker. A couple of just clarifying questions for the proponent of the bill, please.
You may proceed, madam.
Thank you. Through you, Mr. Speaker, just for clarification for me, would this help to get the codes? I know in public safety we've been having some conversations about updating some outdated codes. And would this help to get those codes updated through you, Mr. Speaker?
Representative Becker.
Through you, Mr. Speaker, this specifically would not affect the codes specifically. What this is about is to have the agencies be on a regular schedule to review their current regulations and to identify those which are obsolete, which no longer comply with current law, about which they've received a written complaint, to bring those to the attention of the Committee of Cognizance, and then a public hearing would be held to have a discussion around that and allow for public input. But it would not specifically address the good representative's concern. Through you, Mr. Speaker.
Representative Zupkis.
Thank you. And through you, Mr. Speaker, so this would help speed up the process then. So once the codes are identified, they're completed, this would help them, so it wouldn't be as far out of date. It would help the process to move more quickly. Through you, Mr. Speaker.
Representative Becker.
Through you, Mr. Speaker. Mr. Speaker, the codes to which the good representative is referring are generally national codes, and then the state adopts those with some modifications. That is a process really dealing with new regulations or updating regulations. This is addressing regulations currently on the books, review of those and identification of those which are obsolete, outdated, in need of change, about which complaints have been received. So it's, again, I think it's not quite what the good representative is speaking to at this point. Through you, Mr. Speaker.
Representative Zupkis.
Thank you, Mr. Speaker. And through you, so I guess my question would be then, once codes are adopted, it would just require the agency to review them annually to keep them updated. Through you, Mr. Speaker.
Representative Becker.
Through you, Mr. Speaker. The process outlined in this bill is to have the Committee of Cognizance coordinate with the agency to set a date by which that agency will deliver a report that I previously described, And that report has to happen at least once every 7 years. Once every 7 years that would happen. So again, in terms of the codes to which the good representative is alluding, those are updated from periodically and from time to time on a national level and are then taken up by folks in the state to adopt them to Connecticut's needs. So that would happen on a different schedule than what we're talking about here. Through you, Mr. Speaker.
Representative Zupkus.
Thank you, Mr. Speaker. I appreciate the good representative's reply to my question. So this is a good bill. I wish it would help us out a little bit, but I will be supporting this bill. So thank you.
Thank you, Madam. Representative O'Day.
Thank you, Mr. Speaker. Just a few questions for the proponent of the bill, if I may.
You may proceed, sir.
My understanding, the current requirements are that regs review has to have a public hearing with the Committee of Cognizance. Is it annually to review the current regs? Through you, Mr. Speaker.
Representative Becker.
Through you, Mr. Speaker, no. The current law requires the Regulation Review Committee to set up a schedule with the agencies to have them submit one of these reports sometime over the course of the next 5 years. And only upon receiving that report, at the point that the Reg Review Committee receives that report, within 30 days of that, Regulation Review is required to hold a public hearing jointly with the Committee of Cognizance. Through you, Mr. Speaker.
Representative O'Day.
And when was the last time that was done, to your knowledge? Through you, Mr. Speaker.
Representative Becker.
Through you, Mr. Speaker, a question back to the questioner when he asked when was the last time that was done. By that, does he mean holding a public hearing after receiving a report? Through you, Mr. Speaker.
Representative O'Day.
Yes.
Representative Becker.
Through you, Mr. Speaker. I have no firsthand knowledge of when that was done. However, another representative who has served for a very long time on the Reg Review Committee and who's highly esteemed in this chamber and to whom the good representative is pointing, has put forth I think his best remembrance of when that might be, which was sometime in the mid-90s. Through you, Mr. Speaker.
Representative O'Day.
Thank you, Mr. Speaker. And without pointing any fingers or mentioning any names, my understanding is that individual has very much familiarity with our processes since he was here for a very, very long time. And so I stand in strong support of this, this bill. I think I was recently at a New Canaan lacrosse game, and one of my constituents came up to me, and by the way, we won against St. Joe's. And they did complain to me why we don't review our regulations more regularly. And I frankly at the time didn't have the answers to how often our regulations were reviewed on number, length, and how they can be reduced. And so I very much appreciate the chairman's bringing this forward, and I think it's a fantastic bill. I truly believe this will be some of the best legislation we get through this, this House this year, and I thank the chairman very much for bringing this forward. Thank you, Mr. Speaker.
Thank you, sir. The distinguished gentleman from the 69th District, Representative O'Neill.
Thank you, Mr. Speaker. And if I could just try to add a little bit more information. I believe it was sometime in the mid-1990s, may have even stretched into the later part of the 1990s, when the Regulations Review Committee last conducted the review in conjunction with the committees of cognizance, having all of the agencies conduct a review of their regulations and then holding a public hearing on the ones that they thought might be worthy of either a modification or perhaps repeal based on that review. Taking it a step back, and I don't recollect whether the chair of the Regulations Review Committee in his original presentation mentioned it, but the whole concept of having this kind of a review, as I recall, stemmed from legislation proposed by a then chairman of the committee who was from Norwalk, Representative Knopp at that time, later Mayor Knopp of Norwalk, who suggested that the regulations ought to be sporadically reviewed. Up until that time, there had never been a systematic a comprehensive review of all the regulations required by the statutes to be done by anyone. And so the idea was to put it in the hands of the Regulations Review Committee, which seemed reasonable at the time, since the Regulations Review Committee is the one that reviews the new regulations as they come up. The whole idea was to have this be done, as was indicated, on a 5-year schedule, to have agencies come in and hold these reviews, have them tell us whether they had any regulations that seemed to be worthy of repeal or no longer necessary, obsolete, things like that. And it should be noted that we have regulations going back at least to the 1960s. I don't remember if we have any that are much older than that. And so some of these regulations go back to a very distant time, 50 or 60 years back in the history of this state of Connecticut. And what we've done over the years, a lot of the things that used to be done in statute were being done in regulation. And in addition, a lot of the things that we were required to do by federal law were done in regulation. The handbook, the workbook for the Department of Social Services, everything they did was adopted as a regulation. So we had tons of regulations that were passed through, and many of them, it seemed, hadn't been looked at in a long time. Unfortunately, the Regulations Review Committee seems to have not been able to get this process to keep going. We did it once. We went through the regulations that they had. There were some repealers, but then that was the end of the process, and it was always postponed year after year after year. So it doesn't seem like the Regulations Review Committee is the right place for this sort of thing to be done, especially since the committees of cognizance have an active interest, perhaps more so than the Regs Committee, in the substance of what's going on in a particular area. They might perhaps be more inclined. I think it'll be interesting to see if the process is more diligently pursued when it's being handled by the committees of cognizance than it has been by the Regulations Review Committee. But we know that the system has not worked well with the Regulations Review Committee, and I think we would all agree that some kind of a periodic review is something that we should have done to our regulations, especially now that we've had a regulatory system in place for decades, and we've had some that have gathered quite a bit of dust, it seems, over the years. So I think that the underlying bill is certainly a good idea, and I think the amendment takes it in a good direction as well. Especially the grammatical types of changes. And just for everyone's edification, and especially the ranking member on the GAE committee, I believe that there is a statutory provision that says that if an agency is merely renumbering regulations, that they can go through a similar process of sort of just an expedited submission to the Regulations Review Committee, so that the idea of correcting grammatical, typographical, and that type of non-substantive error is something that is not that far afield from what has been done in the past in a somewhat different sector of the whole regulation process. So I think the amendment is a good amendment. It improves on the bill, which I think is a good bill, and I think that it will not expedite things that much, but I think it will perhaps provide a little bit of an acceleration in the process, maybe a little bit of cleaning up of the regulatory process, and will save some time and effort within the process that we've developed over the last several decades. Thank you, Mr. Speaker.
Thank you, sir. Will you mark further on the bill as amended? Will you mark further? Will you mark further on amendment before us?
No, we did not. We did not. Yes, The board is wrong, and we are correcting the board.
Will you mark further on House Amendment A? Will you mark further on House Amendment A? If not, I'll try your minds. All those in favor, please signify by saying aye. Aye. All those opposed, nay. The ayes have it. The amendment is adopted. Will you mark further on the bill as amended? Representative Becker.
Thank you, Mr. Speaker. Mr. Speaker, I also want to make sure that I moved adoption of the underlying bill as well, because I believe you asked me to move adoption of the amendment, so I want to make sure I do that as well. So I move adoption of the bill now as amended. In addition, Mr. Speaker...
You moved for acceptance initially.
Acceptance and...
That was already done.
Thank you, Mr. Speaker. Mr. Speaker, I just want to take an opportunity before we take the vote to thank a number of people who played a role in this. The chairs and ranking members of the GAE committee, Representatives Jutila and Smith, Senators Cassano and McLaughlin, my fellow co-chair of the Regulation Review Committee, Senator Chapin, and ranking members Senator Doyle and Representative O'Neill, two senior members of this chamber who testified on behalf of the bill, the good Representative Godfrey and Representative O'Neill, members of our nonpartisan staff in LCO and OLR, particularly Shannon McCarthy, Louise Nadeau, Rich Hanratty, and Terry Adams. I'd also like to thank Brian O'Connor of the Speaker staff for his help, and Chris Smith and Chris Drake from the administration, with whom this would not have been possible. So I'd like to thank all those people for their help in this. It's been a real team effort, and good bill ought to pass. Thank you, Mr. Speaker.
Thank you, sir. Will you mark further on the bill as amended? Will you mark further on the bill as amended? If not, will staff and guests please come to the well of the House? Will the members please take your seats? The machine will be opened.
The House of Representatives is voting by roll. The House of Representatives is voting by roll. Will members please report to the chamber immediately?
Have all the members voted? Will the members please check the board to determine if your vote is properly cast? If all members have voted, the machine will be locked and the clerk will take a tally.
146-04.
The clerk will announce the tally.
House Bill 5498, as amended by House A. Total number voting 146. Necessary for passage 74. Those voting A, 146. Those voting A, 0. Absent not voting 4.
The bill is amended is passed.